Hello, I'm Michael Tessaro, and I prepared this case note entitled Feeble Fine for Fossil Fuel Fail. Well, you probably gather I like alliteration. And I've been looking at the Khalid power station case, which came down in the federal court earlier in February this year. And there you can see the power station generator unit and after the explosion which occurred. And it's a pretty interesting case, I think. I just read recently. Bit of background about myself. I'm a competition and consumer lawyer, and I run my own practice, Salo Consulting, which I've been running for 17 years, and I help companies, individuals in competition and consumer law matters. Also, do a bit of expert consultancy work for legal publishers on competition and consumer law, and also have a part-time role with NCAT doing a variety of cases, including some consumer law cases. Prior to that, I worked at the ACCC for 15 years, a variety of roles, including enforcement and mergers. Outline the case, I'll talk a bit of introduction, what happened, why did it happen, then look at the judgment of Derrington. Then I'll explain why I think the fine was feeble, and then a final irony. Now, the Callide power station located in Queensland, it's a big one. It supplies 20% of Queensland electricity, and it actually exploded, or one of the units exploded in 2021, leading to extensive outages across Queensland. The AER decided to pursue litigation against the operators, and the decision, I said before, was handed down in February this year. And the operators were fined $9 million, but pretty much consented to the fine of that amount of money. Now, what happened? As I said, there was a catastrophic failure on the 25th of May 2021, which resulted in the Callide C4 generating unit blowing up. And there are four generating units, so it wasn't the whole thing blew up, but one of the four units blew up. And it arose as a result of a substantive failure of the major infrastructure to operate properly. And the consequences were the equipment all blew up, there was a potential for people to get killed, there was a massive loss of power to the grid, and there have been significant long-term and wide-ranging impacts to the NEM. The loss of power, like 3,045 megawatts of generation, was lost, sucked into the generator, which is over one-fifth of the installed generation capacity in the entire Queensland region. As a result of all this electricity being sucked into the generator, consumers lost 2,300 megawatts of power, which resulted in a lot of them being without power in northern New South Wales and Queensland. And about 500,000 consumers ended up having no power. Now, what were they doing? They were just trying to change a battery, that was all. So they're basically, the operator CS Energy was trying to replace the C4 battery charger. So the first step is to connect the battery charger to the existing battery and then fully charge it up. And disconnect one battery, connect the other battery, then disconnect the station energy supply, and then connect it all back up again. So there's 5 steps, and the problems arose step 4. So when they were trying to do the interconnector, basically the C4 battery charger failed to respond quickly enough, didn't maintain the DC voltage, and just started dropping rapidly and went all the way down to 0 volts. And because it was not, the other battery wasn't connected yet, there was no alternative supply of DC power. So when one went down to 0, there was nothing left. So what happened then, and this is technical, and I've got to admit I probably don't fully understand it, but effectively this particular generator, the steam that is generated from burning the coal, that stopped being produced, the valves closed, and the generator is no longer getting steam to run the generator. And instead of it becoming being a generator, it starts motoring asynchronously. And that means that effectively it's starting to drag power into it as opposed to generating power. So as you can see there, I didn't quite understand the lost excitation. I didn't quite follow that. But the key thing here is there was reverse power. The C4 generating unit began motoring instead of generating. It began to draw power into itself from the power system, from the National Electricity Network, which is very problematic. And because there was no DC power, all the various protection systems that should have come in to prevent what ended up happening, the catastrophic event. They didn't work. So because all the protection systems failed, then it didn't result in the generator circuit breaker acting to disconnect this particular unit from the broader power system. It kept operating, and this is 3,000 revolutions a minute, it's going really fast, dragging in all this electricity from outside sources. It's getting very, very hot. It's not being able to cool itself down. The lubrication is going, and it's just heating up. There's hydrogen in the system, which is used to cool down the system. When the seals all burn up, then all the hydrogen escapes, so there's less things keeping it cool. There's all these short circuits occurring, and the catastrophic failure occurs. There's excessive wear, course operation generating units, and what happened here got so hot, and the shaft that spins around rapidly came out of alignment and ended up scraping against and catching on the casing, and it just basically blew up. And the rotor shaft tore apart in 9 different places and scattered all this debris all across the room, this big room. And it was still attached to the generating unit was still attached to the grid. So it's dragging in all this electricity, there's big electrical arcs forming, all the copper conductors are vaporizing, and it's drawing 300 megawatts of power from the grid. This is just like something you see on TV, like a movie, isn't it? Anyway, so you can see that's a picture of the unit, and then on the right there, that big silver thing, that's the steam, and that's where the steam's generated. Well, that was closed off, and then on the left, the orange thing on the left there, the smaller one, that's where the generator is, and it's spinning around at 3,000 revolutions per minute. And because it's dragging in so much electricity, it's getting really hot. It's up to 730 degrees Celsius. Things are just vaporizing, burning up. It's coming out of alignment because there's no lubrication, and then it all blows up. And as you saw for the very first photo, most of the explosion occurs on the right-hand side because that's where the real heat is being generated. Now, why did it happen? Well, this is interesting. There's a couple of reasons that it happened which weren't the fault of the operator. So, because the voltage went down a particular amount, it fell between two sort of tolerances, which was unfortunate. If it had been a bit higher, there'd be a particular consequence, and this wouldn't have happened. If it had gone a bit lower, a different consequence would have occurred. So there was a bit of bad luck there. But the key thing here is there was a final fail-safe mechanism which could have prevented a lot of the damage, and that was this automatic changeover switch. And as you see there, it's designed to transfer some of the DC systems automatically to the standby supply of DC power upon a loss of the preferred supply. And if that had occurred, then it would have had an impact on the outcome. The problem here was there'd been a problem with the ACS back in January 2021, and it got broken, and accordingly it didn't work automatically. It had to be operated manually, which wasn't going to happen in this particular context. So effectively, the failure of the operator to fix this ACS back in January led to it not being available when this event occurred to operate automatically. And if it had acted automatically on the day, and this is what the judge said, had the ACS operated, it would have restored the DC supply, and as a result, the wide generator protection system would have responded and disconnected the G4 generating system from the grid. So the fact that the ACS wasn't fixed meant it automatically didn't disconnect the generator from the grid, which resulted in so much of the problem from this mass explosion. So the case was brought by the AR, and Callide admitted that it breached a couple of provisions of the National Electricity Rules 415A1, ensure that the generating units met or exceeded the relevant performance standards, and clause 5.2.5A1, which required the operator to ensure that the unit was planned, designed, and operated to comply with performance standards. So 2 breaches of the law. As a result, they agreed to pay a civil pecuniary penalty of $9 million, which sounds like quite a lot, doesn't it? Now, as noted earlier, the judge said, well, at first blush, this might seem like a technical breach, but really it's very serious. You know, this resulted in a lot of expensive equipment being blown up. It could have killed some people. It results in a lot of harm to the grid and to consumers. And the spot price went through the roof. So you can see in the second sentence there, you know, the 12-hour forecast spot price in the relevant period after the 25th of May 2021 had been 169 megawatts per hour in Queensland and 43 megawatts per hour in New South Wales, and that rose to $5,124 megawatts in Queensland and 6,848, sorry, 2,542 megawatt per hour in New South Wales. And these were the other consequences arising from the explosion. As I said earlier, the loss of the Callide C4 service 2 years before it came back online. As a consequence of this dragging electricity into this generating unit, 9 other major generating units in Queensland tripped out. And as a consequence, that resulted in so many consumers having blackouts. As I said earlier, 1/5 of installed generation capacity in Queensland was taken out. 500,000 consumers suffered a blackout. Also, it resulted in the tripping of major transmission lines, and basically Queensland was separated from the rest of the national energy market, electricity market, for a period of time. Caused the AEMO had to activate some particular processes to get some quick prices to get some electricity back on, and so that cost the market $461,000. And as I said, you know, in the previous slide, or the 2 slides earlier, that the spot prices went through the roof for a period of time after the failure. Now, the judge looked at the various penalty factors and went through them all. He ultimately concluded that the penalty was appropriate and agreed to the $9 million. Some of the ways he approached the penalty factor seemed a bit strange to me. He said that no previous conduct by the operators was a mitigating factor. I don't think that's right. I think if you've got previous form for breaching the relevant legislation, that's an aggravating factor. The fact you haven't breached the law before doesn't really mitigate your breach. I think it's a neutral factor. He talked about the fact that a compliance program was required to do under the relevant rules and that it didn't work. So I think that was probably neutral in terms of the assessment of the penalty. He looked at the sign of the contravener, $197 million for the joint venture company in the 2020-2021 financial year. He concluded that the conduct was not deliberate. But you're thinking, you know, I know it's not deliberate, but it's extremely reckless. So it's pretty close to being deliberate if it's reckless. Senior management, the party submitted there was no involvement of senior management. I think the judge sounded a bit sceptical about that, and I think that has to be the case. There's clearly no way in the world that the decision to change this battery was made by lower level staff members, and there's no way in the world that the decision not to fix the ACS was made by lower managers. Clearly that was a decision that, you know, would have gone to the board of directors, and they would have made a decision not to spend the money to fix the ACS. Discussed cooperation as being a discounting factor, discounting the penalty. I think that's right. And then the culture of compliance discussion seemed a bit puzzling to me, sort of talking about the culture of compliance that as manifested after the event. And I don't think that's the way it's supposed to work. I think you're really looking whether the company had a good culture of compliance before the breach. If that being the case, I think he would have concluded the opposite to what he concluded. I think the culture of compliance is very poor. That's one thing that came out when there was after this event, there was an investigation and reports done, and the conclusion was that the company had ignored a lot of earlier problems in the facility, had a very poor safety record, you know, a lot of allegations of cost cutting. Clearly the failure to fix this ACS seems to be classic cost cutting. So it seemed to me the culture of compliance factor should have gone against them. Now, he did say at paragraph 92, the judge, at the relevant time, these 2 particular provisions were classified as Tier 1 civil penalty provisions, and that As a result, the maximum penalty available on the basis of the agreed facts is $10 million. Now, that immediately doesn't look right because there's two contraventions, and if they're both worth $10 million, the maximum is actually $20 million. And they do arise from different things. There's two different provisions which were breached by the operators. So at that stage, you're thinking, that doesn't sound right. When you go into a bit more, it seems even more way off because, as you see, the National Electricity Rules were amended by the Statutes Amendment National Energy Laws Penalties Enforcement Act 2020, and it brought in new penalties. So the $10 million applied earlier, but effectively from 29th of January 2021, which is a few months before the explosion occurred, the penalties have been increased, and they were now, for a Tier 1 contravention, they were $10 million or 3 times the benefit or 10% of annual turnover, whatever is the highest. So when you do the maths there, the penalty was much higher than $10 million. You got 10% annual turnover, 197 million, you got two contraventions. So there's the maths. 10 times 197 million times 2 is 39.4 million. So the maximum penalty here was actually closer to 40 million, not 10 million. And for some reason, the judge is saying in that earlier paragraph, the maximum is 10 million. And he thought it's at the higher end of the scale, but it was nowhere near the higher end of the scale. And I don't think that the penalty has achieved specific deterrence, because since this explosion in 2021, there's been further problems at this power station. There's been stories about other problems occurring and people being at risk of being injured and killed. It hasn't had, it seems, specific deterrence effect on the company. Now, final irony, what does the word callide mean? So I looked it up, and ironically, it's got two very different meanings. The first is expertly, skillfully. And you would not say that this company has exercised its role in running this power station in an expert or skillful manner. It's had numerous safety issues. It didn't fix an ACS switch, which would have prevented the full scope of this problem with the meltdown of its C4 generator. So it's ironic that its name means expertly or skillfully. However, ironically, it's got a second meaning, which is cunningly or craftily. And I think that sort of seems to be more accurate, because I don't know how this happened, but somehow the judge was led to believe that the maximum penalty was $10 million when it clearly wasn't, and that resulted in them getting a penalty which the judge thought was the maximum that could be imposed, when actually it was a quarter of the maximum that could be imposed. So there was something happened there where the judge misapprehended what the maximum penalty was. So just a final commentary, it's a very serious breach. This is very bad conduct. It's a series of earlier problems at the particular facility. The company seems to be cutting corners in terms of its maintenance, not fixing up fail-safe device like the ACS is really quite unforgivable, and the consequences of them failing to do that was significant in so many respects, and they were sort of fortunate that nobody was killed in this particular scenario. Secondly, it seems to me the court was definitely under misapprehension as to what the maximum fine was for this conduct. Sort of thought it was the maximum $10 million. The way I look at it, it was clearly much, much more. Maybe I'm mistaken, but I don't think so. And then finally, because the judge was under this misapprehension, it resulted in a feeble fine for this fossil fuel fail. So that's all I had. Hopefully that's been interesting. And if you have any questions, feel free to give me a call or drop me an email. Bye-bye.